evening. Welcome to Community Justice Organisation New Zealand's training session. And I am Karen Harding, and I am here to take you tonight through the synopsis of the law on applying for summary judgment and strikeout applications. The goal is to do this in a wrap-up for you in 5 minutes, so let's see how we go. So let's start with the key points. So the first point is that if you're going to have a defence based on the Limitations Act, then the onus is on the defendant to prove that that Limitation Act defence applies and that it's a complete answer to the statement of claim. So if the defence applies and the plaintiff argues extension, then the onus moves to the plaintiff. If it's a clear case that the Limitations Act defence is made out, the court can dismiss the claim on the basis it's a waste of time, it's frivolous and an abusive process. A claim can be struck out if the pleadings disclose no cause of action. The onus is on the plaintiff to show reasonable cause of action in relation to each allegation. The plaintiff needs to establish sufficient basic facts to at least raise a prima facie case against a defendant. The test is whether on the material before the court, and considering the current law, it has been demonstrated that the alleged causes of action are so clearly untenable that they cannot succeed. The court can consider the position of defendants who may be at risk of not recovering their costs in defending untenable claims. So the court can grant defendants summary judgment if they satisfy the court that none of the plaintiff's causes of action and their statement of claim can succeed. This requires also that the plaintiffs are unable to amend their claim, so they're unable to remedy the faults that the defendants rely on. The defendants must show that none of the plaintiff's cause of action can succeed. If so, the court can grant summary judgment against the plaintiffs. It's like Skittles. To strike out a plaintiff's claim, the court must be certain that it cannot succeed. So summary judgment might be over the whole claim. And strikeout is if you're going for each of the actions. If you manage to strike them all out, then you've got strikeout and summary judgment. To strike out a plaintiff's claim, the court must be certain it can't succeed and consider that it should be precluded from going forward. So if the defendants can show a claim as a matter of law is untenable, or there is a defence of a legal nature, the claim can be struck out. A claim can be struck out if the defendants are able to establish a complete answer to all the plaintiff's causes of action, even if they constitute separate claims. The court can strike out pleadings where much of the pleadings contains irrelevant material and are unintelligible pleadings where it is difficult or impossible to understand them. Claims can also be struck out on the grounds that they are frivolous, vexatious, or likely to cause prejudice or delay, which requires some impropriety or abuse of the court's processes. The court can consider policy factors about maintaining public confidence in the administration of justice, which ultimately depends on the rule of law. The court also has an inherent jurisdiction, enabling it to restrain and strike out vexatious and oppressive litigation, frivolous proceedings that trifle with the court's processes, proceedings that lack the seriousness of matters required for the court's determination, proceedings that misuse judicial processes and undermine confidence in the administration of justice, proceedings that attempt to relitigate matters already determined, proceedings that use court processes for an improper purpose, proceedings with no live issues or that no longer have any relevance or are being pursued for ulterior motives, proceedings that are a waste of time and resources. One of the differences between the applications with summary judgment is that you can file affidavit evidence with your summary judgment application, and that should be an application dealt with in open court. Summary judgment must not involve material disputes of fact. The affidavits must show like a complete defence, and you can file expert evidence affidavit. They have to have an aura of credibility. It has to be resolved on the papers so that it's not something that requires a witness to be in the witness box or to be subject to cross-examination. Summary judgment is where the defendant has a clear answer that the plaintiff cannot contradict. That's our 5-minute wrap-up.